Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, this is a video that's going to be discussing U.S. tourist visa denials, specifically for the girlfriends of American citizens. And as my producer, who is helping me put these videos together, commented right before we began shooting, he said, wow, that's a really specific title. And I said, well, there are a significant number of people who call our offices rather frequently and basically have this exact question. You know, we sought a tourist visa, we were denied, what do we do? Well, the short answer is it depends. In many cases, it's my opinion that most people who are seeking a U.S. tourist visa for the significant other of an American citizen are going to be denied. Now, strictly speaking, there are some finer lines with respect to this issue and the issue of what's called Section 214B of the Immigration Nationality Act. There's another video on this channel which specifically gets into the details of what's called Section 214B, but just a quick overview. Basically, pursuant to the provisions of Section 214B, the consular officer adjudicating a U.S. tourist visa case must go ahead and make an analysis of strong ties, weak ties. Strong ties to the home country of the applicant or a third-party country outside the United States, and weak ties to the United States. In most cases involving single-tie women, especially single-tie women who have a significant other who's an American citizen, the strong ties, weak ties analysis is going to go against the applicant. It's going to go against the girlfriend or boyfriend, for that matter, of an American citizen. But the thing to take away from this video is, first of all, one thing I should really note with this video is there are those that have contacted me in the past with respect to a U.S. tourist visa, and they've said, well, what if I just don't, we just don't tell them that she's got an American boyfriend. I find that to be very unwise and imprudent. I don't think it's wise to it's never wise to lie to the immigration apparatus, and it's not wise to lie to any of the authorities at the immigration offices, either in the United States or the consular officers abroad at a U.S. embassy or consulate abroad. So the thing to take away from this video is, first of all, don't lie. If you have an American boyfriend, just I would say disclose it. Now, some people say, well, it doesn't actually ask for, do you have an American boyfriend? Although on the Department of State forms, the DS-160, they actually do ask where you're going to be staying, and lying about that can be a problem. There's all kinds of problems associated with lying on an immigration form or lying to an immigration officer. So, and the other thing with respect to lying is it could lead to a finding of inadmissibility to the United States on the ground of fraud and misrepresentation. So lying in one of these adjudications is really not a good idea. Now, the next thing is, one can apply, and as long as they're being upfront about their intentions and what they're going to do in the United States, one can go ahead and apply. But again, 214B is a really high threshold for most folks in these situations. And frankly, they take the opinion that, look, there's a pretty good chance if you've got an American boyfriend, you may use your tourist visa to go over the United States, marry him, and adjust status to lawful permanent residence in the United States. The reason they take this position and make this assumption is because it's happened quite frequently in the past. In fact, it was not an infrequent occurrence at all in the past. So the only reason I bring this up is because that's one of the reasons why the denial is occurring. So now what do? You've gotten a denial. Well, in most cases, the denial is going to be very difficult to overcome because, quite frankly, the circumstances in the case don't warrant a change of decision. There hasn't been a material change in circumstances with respect to the tourist visa being denied, and simply applying again and presenting different evidence probably isn't going to get you there. A lot of people ask me, can the decision be appealed? Well, strictly speaking, no. Pursuant to what's called the doctrine of consular non-reviewability or consular absolutism, the consular officers have pretty much unfettered discretion, at least from a fact-finding standpoint. If you're looking at this from as the consular officer is the person on the ground who is the primary finder of fact, the legal and the immigration apparatuses both look at their fact-finding function in such a way that they basically take the position that they're in the best position to make the decision. They are literally the boots on the ground person who's been entrusted with making that decision, and we're going to go ahead and trust that they made the right one, and we're not going to review and have an appellate system with respect to consular decisions. This is actually fairly old case law. It dates back to I think it's the early 19th century, and I believe the major case, I remember reading it one time, involved an American, or actually it wasn't even American, it was a foreign national suing a consular officer like in the Supreme Court, and the Supreme Court basically came up with this doctrine and said, look, we're not going to review every little detail of every little case, or really review much at all what consular officers are doing in their function as an adjudicator of visa applications. We're simply not going to go down that road. So appealing the decision isn't really an option. It may be possible to request a reconsideration, and if there's other compelling documentation and evidence that can be submitted, consular officers are reasonable people. If there's a valid reason for allowing an individual to go to the United States, they're not going to just summarily reject them without cause if there really is a compelling reason. So yeah, it may be possible to get them to reconsider. The next set of analysis really comes down to the circumstances of the given couple. And I want to be very, very clear. No one should ever tailor their life choices in order to get immigration benefits. Okay, so getting into a fiancé relationship or a marital relationship simply to get an immigration benefit will probably be deemed to be a sham marriage issue and could be deemed to be fraud, misrepresentation, or immigration fraud. And falls into the category of like marriages of convenience. So I want to be very, very clear up front, or right now in this video, one should not simply start looking at seeking like family-based visas based on the denial of a girlfriend or a boyfriend for a tourist visa simply because it's the next option. It's not. It is circumstantially dependent on the given facts of a couple's case. But if there really is a genuine intention to marry a foreign national in the United States, in this case we're specifically talking about, let's say, a Thai girlfriend, then yes, a K-1 fiancé visa may be the viable option, and that would be the type of case where, first of all, Section 214B doesn't apply, and secondly, yes, it's a longer process compared to the tourist visa application, but once the process is complete, that individual can, at least upon adjustment of status in the United States, can remain in the United States in lawful permanent resident status. In theory, down the road, they could naturalize to U.S. citizenship. So if there's a genuine fiancé relationship, or if the couple later gets married, legally married, then there's a marriage visa option down the road too. So the thing to take away from this video is, first of all, unfortunately, if you're watching this, you've probably been denied or your girlfriend's probably, or boyfriend's been denied for a tourist visa from Thailand. It's not exactly an uncommon thing. There may be other options depending on your circumstances. There may not. And unfortunately, 214B is really a tough threshold to overcome. If you genuinely engage in a more serious relationship, then there may be immigration visas, there may be immigration options available. There are other videos on this channel specifically about the K-1 fiancé visa, as well as the CR1 and IR1 spouse visas, as well as the K-3 spouse visa. So there may be other options. But again, the thing to take away from this video as well, immigration benefits should not dictate one's life choices, and sham marriages and fraud and misrepresentation are serious findings of inadmissibility. So one should only be seeking a fiancé or marriage visa if their intentions are commiserate with those visa benefits.